Hello friends, on the last occasion we discussed section 17 of the Indian Evidence Act. There we found the definition of admission, but section 17 does not tell us who are the persons can make admission. We will find that from section 18. I will start my discussion today from section 18, admission. Read with me. By party to proceeding or his agent, by suitor in representative character, by party interested in subject matter, by person from whom interest derived. Statements made by a party to the proceeding or by an agent to any such party whom the court regards under the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. So, statements made by a party to the proceedings, any party of any suit or proceeding, or by his agent to any such party, agent of any such party to the suit, or the party himself, whom the court regards under the circumstances of the case as expressly or impliedly, either expressly or impliedly, authorized by him to make them are admissions. By suitor in representative character, statements made by parties to suits suing or sued in a representative character. We will find the definition suit of in representative character in CPC, where I have filed a suit on behalf of a mass of people. Statements made by parties to suits suing or sued in a representative character are not admissions unless they were made while the party making them held that character. Say, I am a liquor shop owner. I got license from the government to sell liquor. And there are lots of other liquor shop owners in my area. Say in Delhi, there are 500 other liquor shop owners. Government has changed some policy in issuing license for the liquor shop. And all the liquor shop owners, licensees, are aggrieved with it. Now I filed a suit in representative character against the government. That means I filed the suit for myself and as a representative of all the liquor shop owners. Now, statements made by parties to suits suing or sued in a representative character are not admission. I cannot make any admission while I have filed a suit in representative character unless they were made while the party making them held that character. I can file the suit while I am a liquor shop owner, or I can file a suit but I do not have any liquor shop. When it will be admission? When? Unless they were made while the party making them held that character. If I have the liquor shop, I am entitled to make admission. But if I do not have liquor shop, I am not entitled to make any admission. Statements made by party interested in subject matter. Persons who have any proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement in their character of persons so interested. statements made by any party interested in the subject matter. Persons who have any proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement of admission in their character of persons so interested. Interest should be that proprietary interest or pecuniary interest over the subject matter. When I am making that statement, I should have that proprietary or pecuniary interest over the subject matter. If I have that interest while I am making that statement, that can be treated as admission. Otherwise, it will not be treated as admission. Number 2, by person from whom interest derived. Persons from whom the parties to the suit have derived their interest in the subject matter of the suit are admissions if they are made during the continuance of the interest of the persons making the statements. I derived interest from my predecessors. While my predecessors was the owner of the property, I got the ownership by way of inheritance from my predecessor. And when my predecessor was the owner of the property, he made some admissions, some statement. Persons from whom the parties to the suit have derived their interest in the subject matter of the suit. I derived interest in the subject matter of the suit from my predecessor, and statement was made by predecessor are admissions if they are made during continuance of the interest of the persons making the statements. Now, I want to discuss few points. Section 18 of Indian Evidence Act lays down 5 classes of persons who can make admissions. Note it. Sorry. Party to the proceeding, a agent authorized by such party, party suing or sued in a representative character making admissions while holding that character. Number 4, person who has any proprietary or pecuniary interest in the subject matter of the proceeding during the continuance of such interest. And lastly, number 5, person from whom the parties to the suit have derived their interest in the subject matter of the suit during the continuance of such interest. These are the 5 classes of persons who can make admission as per section 18. Few case laws I have studied, and from those case laws I want to just mention few points, like admission by counsel, lawyer. What is that? Admission of fact made by a pleader in the conduct of a suit of his client on behalf of his client are binding on the client. So, when a lawyer, while conducting a suit on behalf of his client, any admission made by such lawyer will be treated as admission for the client. But a party, what will be admission? Admission of fact. But a party is not bound, generally speaking, by pleader's admission in argument on what is a pure question of law. So, admission by pleader should be only on the admission of fact, not on the question of law. In case of any admission by the pleader on any question of law, that will not be binding upon the party. But admission of fact by the lawyer will be binding on the party. Now, think about the case where there are more than one defendant. Then the question is, if there is one admission by one defendant, whether that admission will be binding on the other defendants or not. An admission or a confession of judgment by one of the several defendants in a suit is no evidence against the another defendant. Thus, the admissions by one defendant will not be relevant against a co-defendant. What is that? If there are 4 defendants in a suit, defendant number 1 made some admission. Now the question is, admission made by the defendant number 1, whether that will be binding on the other 3 defendants or not. Answer is, it will not be binding upon the other defendants. It will be binding on the defendant who is making the admission, but not on the other defendants. But now think the case of a partnership firm. XYZ are the 3 friends who formed a partnership firm. Now, if X made some admission, whether that will be binding on Y and Z and the partnership firm or not. In the case of defendants, more than one defendants, admission by one defendant will not be binding on the other. But what will be in the case of a partnership firm where there is 2 or more partners? The answer is, the partners are agents of one another so far as the business of partnership is concerned. Partners are the agents of one another. X, Y, Z are the 3 partners of a partnership firm. Measures ABC. Now X made some admission, whether that will be binding on the partnership firm measures ABC and YZ or not. In partnership firm, every partner is the agent of the other partners as well as the partnership firm also. So if a partner is the agent of the other partners and the partnership firm, then the admission made by Mr. X will be binding on the partnership firm as well as upon the partners Y and Z. Now I am coming to section 19. Admissions by persons whose position must be proved as against party to suit. What is that? Statements made by persons whose position or liability it is necessary to prove as against any party to the suit are admissions if such statements would be relevant as against such persons in relation to such position or liability in a suit brought by or against them, and they are made whilst the person making them occupies such position or is subject to such liability. Very difficult. Let us go to the illustration. After going through the illustration, the section will become very easy. A undertakes to collect rents for B. B sues A for not collecting rent due from C to B. A is appointed by B to collect rent on behalf of B. But A did not collect rent from C. So B filed a suit against A for not collecting rent from C. Now A denies that the rent was due from C to B. A's defense is there is no rent due by C to B. The state a statement by C that he owed B rent is an admission. But when A said that C has no no rent due to be collected, this was A's defense. In the same case, C stated that he owed B rent. When B sued A for not collecting rent from C, A took the defense that there is no rent due from C. And in the same case, C admitted that there is rent due to be paid to B. This statement is an admission and is a relevant fact as against A. If A denies that C did owe rent to B, when A is denying that there is no rent due by C to B, C said that yes, rent is due and to be paid. This statement made by C will be treated as an admission and is a relevant fact against A. This will go against A if A denies that C did owe rent to B. So, what is the matter? Statements, I am again reading the section. Statements made by persons whose position or liability, C, the rent due is the liability of C. It is necessary to prove as against any party to the suit. The liability of C is to be proved against A in the suit. Are admissions if such statements would be relevant as against such persons in relation to such position or liability in a suit. Liability in a suit, what is that liability? The due rent. The question is due rent. If such statements would be relevant as against such persons in relation to such position or liability in a suit brought by or against them, and they are made whilst the person making them occupies such position or is subject to such liability. While C made that statement that yes, rent is due and it is payable, C was in occupation of such position. That means C was a tenant and rent was payable by C to B. At that position, C admitted his liability, that he has the liability to pay rent to B, which A said that C had no liability to be paid, and that's why A did not collect rent from C on behalf of B. I am reading the section once again. It will be crystal clear for you. Statements made by persons whose position or liability, I am talking about C. Statements made by persons whose position or liability it is necessary to prove as against any party to the suit. Here, as against any party to the suit means A. Are admissions if such statements would be relevant as against such persons in relation to such position or liability in a suit brought by or against him. Suit was brought against A. And what is A's liability? A's liability was to collect rent from C, and A said that there is no rent due. So he did not collect rent from C, but C made the statement that rent is due. Now such statement would be relevant and they are made whilst the person making them occupies such position or is subject to such liability. See, at the time of making such statement, is subject to such liability. At the time of making such statement, she had the liability to pay the due rent. Being in such position, she made that statement that rent is payable. This statement of C will be treated as an admission and it will be treated as relevant fact as against A. Today we discussed only section 18 and 19. In our next episode, I will start from section 20. In the meantime, if you have any suggestion, any feedback, query, feel free to write to me. I will be very happy to reply your emails. And if you like these videos, I will request you to please share with your friends. Thank you very much for watching this video. Stay safe.